The morning they came for my house, I was in the back garden, pulling weeds from around the tomato plants. It was just after 7. The Tasman Sea was doing what it does in late autumn, sitting gray and flat and enormous beyond the cliffs at the bottom of Coastal Road, the kind of stillness that makes you feel like the world has paused to take a breath. I had a mug of tea going cold on the fence post. A pair of cararoo were working through the Pohutukawa at the far end of the section, their wings making that deep whomp sound when they lifted. I had lived in this house for 31 years. I knew every sound it made. I heard the car before I saw it. A silver SUV. Then a second vehicle behind it. A ute with a trailer. They turned into my driveway without indicating. My son-in-law was driving the first one. His brother was in the ute. I straightened up slowly. The way you do at 67 when your lower back has opinions about gardening. I set down the trowel. I walked to the gate and waited. My son-in-law, I will call him Derek throughout this, because that is his name, and I have no interest in protecting him, got out of the SUV with the particular energy of a man who believes he has already won something. He was wearing a fleece vest over a collared shirt. He had the look of someone who had practiced what he was about to say. "Graham," he said. "Not hello. Not good morning. Just my name. The way you address someone you consider a problem you are managing." I said nothing. I have spent 40 years as a forensic accountant. I know the value of silence. "We need to talk about the house," he said. "Claire and I have been speaking with the solicitor. Given everything that's been going on with you, we think it's time to make the transition." I looked at the trailer. There were flattened cardboard boxes in it. Moving tape. A dolly for heavy furniture. "You've brought boxes," I said. "We thought it would be easier to start the process today. The facility in Blenheim has a room available." Claire thinks. "Where is my daughter?" I asked. He paused. "Just briefly. She's at home. She found this too difficult." "Of course she did." I looked at him for a long moment. Then I looked at his brother, still sitting in the ute with the engine running. Then I looked back at Derek. "Come inside," I said. "I'll put the kettle on." He blinked. That was not the response he had prepared for. "I need to go back. To explain properly, I have to go back about 14 months. My wife Margaret passed away 2.5 years ago. Pancreatic cancer, which does not give you much time to adjust. We had 34 years together, met when we were both working in Wellington, married young, moved to Nelson when our daughter Claire was 3, because Margaret wanted to raise her somewhere she could see the hills and the water at the same time. I retired from my practice at 63, 2 years before Margaret died, which I am grateful for. Those last 2 years, the good months and then the difficult ones, I was present for all of it. I have no regrets about that. After she was gone, the grief settled in the way it does. Not like a wave. More like weather. Some days clear. Some days impossible to see through. I kept the garden going because Margaret had started it. I kept the house because it was ours. Because every room still had her in it somehow. In the way the light came through the kitchen window in the afternoon. In the particular creak of the third stair. Claire lives in Christchurch with Derek and their 2 children. She flew up several times in the first year. We spoke on the phone every Sunday. The relationship between a father and a daughter after the mother is gone is a particular kind of tender. There is grief shared, but also a new negotiation of who you are to each other without the person who was the center of the family. We were doing that work carefully, I thought. I did not understand then how much Derek had been watching. Derek works in property development. He has the vocabulary of someone who speaks about assets and liabilities the way other people speak about the weather, constantly, casually, as though these are the only subjects worth considering. He had, over the years, made several indirect comments about the house, about what it would fetch now that the Nelson market had moved the way it had, about the section size, about the sea view. He was never direct. He was the type of man who approaches things at an angle, feeling for the edges. What I know now, and did not know then, is that Derek had been in significant debt for about 18 months before he came to my driveway that morning. A development project in Rolliston had gone badly, consents that didn't come through, a building partner who withdrew, cost overruns that he had personally guaranteed. He owed money to several parties. The pressure had been building quietly, the way water builds behind a dam. My house, freehold, Seaview, 600 square meters in a suburb where properties were now selling at 2.2 to 2.8 million, was the solution he had arrived at. What I did not know, until it was almost too late, was that he had already begun the process of acquiring it. 14 months before he arrived with the cardboard boxes, my daughter Claire called me on a Sunday afternoon. She asked how I was sleeping. She asked whether I had been to the GP recently. She mentioned, gently, that she had noticed some things during her last visit, that I had repeated a story twice at dinner, that I had seemed confused about what day it was. I had told the same story twice at dinner. I remember doing it. In fact, I had started telling it, and then realized halfway through that I had told it the night before, and I had finished it anyway because stopping would have been more awkward. It was a story about a fishing trip. It was not a symptom. It was an anecdote I was fond of. As for the day of the week, Claire had arrived on a Thursday. I had said, when she walked in, "Wasn't expecting you until Friday." She had replied that it was Thursday. I had laughed and said I had lost track. I am a widower, living alone. I frequently lose track of days. This is a feature of a quiet life, not a clinical indicator. But I could hear something in Claire's voice that I could not quite name at the time. A quality that I now understand was a script. She had been coached on what to say. She asked if I would consider seeing my GP for a general checkup. I said, of course, I was due for one anyway. She mentioned that it might be worth discussing memory support, just as a precaution. I said I would mention it. 3 weeks later, she came to Nelson again, with Derek this time, and they took me to a lunch at a restaurant on the waterfront. Over dessert, Derek produced a folder. Inside were several documents. "We've been working with a solicitor," he said, "to put together an estate plan for you. It's really just peace of mind. Margaret would have wanted things to be organized." He used her name deliberately. I felt it land. The documents included a general enduring power of attorney covering personal care and welfare, property and finances, all three naming Claire as my attorney. There was also a document granting Derek as co-attorney in specific circumstances, which was framed as a safeguard. I looked at the documents. I am a forensic accountant. I spent 4 decades examining financial records for irregularities, for fraud, for misappropriation, for the subtle ways that people move money and authority away from where it belongs. I have given evidence in court. I have sat across from people who believed they had constructed arrangements I would not see through, and I have, in every case, seen through them. I did not say this. I asked Derek the name of the solicitor. He gave me a firm in Christchurch. I asked for a copy of the documents to review at home. He said, of course. There was no rush. His expression did not change. I took the documents home. I called my own solicitor in Nelson the following morning. His name is Philip, and I have used him since I was 40. I drove to his office and sat across his desk and set the folder in front of him. Philip read through everything without speaking. He has a quality I have always respected. He does not perform his reactions. When he finished, he looked up and said, "Graham, do you want the measured response or the direct one?" "Direct," I said. "This is a general enduring power of attorney with almost no limitations. It covers everything simultaneously. The co-attorney clause for Derek is loosely worded in a way that would allow him to act without Claire's knowledge in a number of scenarios. Combined, these documents would give them full legal authority over your finances, your property, and your personal care decisions. If you were assessed even informally as lacking capacity in any given moment, These documents could be used to make decisions on your behalf without your input. I sat with that for a moment. The GP visit, I said. Philip nodded slowly. If there were a medical record suggesting any cognitive concern, that would support a capacity question. It wouldn't need to be conclusive. It would just need to exist. I thought about Claire's phone call, the repeated story, the mixed-up day. How long would it take, I said, to move a property under these arrangements? If the POA were in place and a capacity question had been raised, with cooperative parties on both sides, months, possibly less. I thanked him. I left without signing anything. What I did next, I did quietly. That is the only way to do it. The first thing I did was contact a colleague, a woman named Rosalind, who had worked in elder law for over 20 years and whom I had met through professional circles in Wellington decades ago. I told her what I had. She confirmed Philip's reading and added several details I had not considered. She told me that what I was describing had a name, elder financial abuse, and that it was, in New Zealand and internationally, significantly underreported because the perpetrators were almost always family members, and the victims were often either unaware until it was too late or unwilling to believe people they loved were capable of it. I believed it. That is perhaps the particular sadness of my situation. I had spent my career looking at the mechanics of how people take from each other, and so I had fewer illusions to lose. The second thing I did was document everything. Every phone call from Claire, noted with time and date and substance. Every comment Derek had made about the house over the years, which I reconstructed from memory and cross-referenced against emails and text messages I had retained. The lunch where the documents were presented. The folder. The solicitor's name. I also called the GP's office and reviewed my own records. There was nothing of concern. I had not seen the GP since the documents were presented. I had made the appointment Claire suggested, and then quietly canceled it before any notes were taken. The third thing I did was update my own arrangements. I drew up a new will with Philip. I established a property trust for the house, a structure that meant no individual could unilaterally sell or transfer it. That any decision required the agreement of 3 trustees, of whom I was one and Philip was another. This took 6 weeks to settle properly. Then I waited. I made tea. I sat Derek at the kitchen table, where I had sat across from a great many people over the years, making decisions about things they thought were already decided. His brother waited outside with the ute. I could see him through the kitchen window, leaning against the bonnet, scrolling his phone. Derek accepted the tea and wrapped his hands around the mug and looked at me with the expression of someone who is trying to project patience but is actually managing urgency. "I know this is hard," he said. "But Claire and I have been speaking with the GP." "Which GP?" I said. A pause. "Dr. Hewson." We explained the situation, and he said, "You spoke with my GP without my consent," I said. "About my medical situation. Claire is she has power of attorney. She does not," I said. Derek stopped. I set my mug down on the table. "I did not sign those documents," I said. "I took them home for review, as I told you I would, and I reviewed them. I did not sign them." He stared at me. I watched the specific journey his face made as it moved from confusion to something harder. "Claire said you signed them. She said she had them witnessed." "No," I said. I kept my voice level. This was not difficult. I have sat across from people in formal proceedings who tried harder than Derek was trying. Claire does not have power of attorney. She never has. I would encourage you to verify that with your Christchurch solicitor, who, I should mention, I have already spoken with. That last part was not entirely true. I had spoken with a solicitor who knew the firm Derek had used, but the effect was what I intended. Derek sat very still. "The house," I said, "is held in a property trust. It has been for 8 months. It cannot be sold or transferred without the agreement of 3 trustees. I am one of them. My solicitor, Philip Barnett, is another. You will find the trust documents registered with Land Information New Zealand. I imagine your solicitor can look those up at your convenience. The silence in my kitchen stretched out long enough that I could hear the cararoo again outside. I also want to tell you, I said, that I have retained records of every communication relevant to what I believe has been an attempt to establish false grounds for questioning my capacity, for the purpose of obtaining legal control of my assets. I have those records with my solicitor. I have also made a preliminary disclosure to the public trust and to a colleague who practices in elder law. Whether I proceed further with those disclosures depends on what happens next. Derek did not speak for a long time. When he did, his voice had lost its earlier quality. It was flat. "This is not what it looks like," he said. "I know what it looks like," I said. "I spent 40 years knowing what things look like." He left with the boxes. I watched from the front step as he spoke briefly to his brother, too quietly for me to hear. His brother looked toward the house once. Then they both got into their vehicles and reversed out of my driveway and drove away down Coastal Road. I went back to the garden. The tea on the fence post had gone completely cold. The cararoo had moved on. The sea was still doing what it always does. The following week, I called Claire. It was the hardest conversation I have had since Margaret died. And I say that understanding what the months after Margaret's death had been like. Claire cried. I let her cry. There were things she said that I do not intend to repeat, because they are private between a father and a daughter, and because pain does not become less real, simply because the person expressing it has done something wrong. What I told her was this. I knew what had been planned. I was not angry, in the way she might have expected. I was, more than anything, tired in the way you are when something you hoped was not true turns out to be true. I told her that I loved her. I told her that I was not prepared to pretend the last 14 months had not happened. I told her that if she and Derek intended to continue their marriage, that was her choice to make. But that Derek was not welcome in my home. She asked if I was going to go to the police. I told her I had not decided yet. What I decided in the end, after several more conversations with Philip and with Rosalind, was this. Derek was already in serious financial difficulty. The property trust meant he could not get to the house. The documentation I had gathered was sufficient to support a complaint under the Protection of Personal and Property Rights Act if I chose to make one. I chose instead to lodge a formal disclosure with the public trust and with the family court registry, not a criminal complaint, but a record. A paper trail. Something that would exist if anything else ever happened. Rosalind told me, when I described what I had done, that most people in my situation did not see it coming at all. That by the time the machinery was in motion, they were often already inside it. I thought about that for a long time afterward. Derek and Claire separated 8 months later. I do not know the details. Claire told me over the phone briefly, without wanting to discuss it. I did not press. The children, my grandchildren, I have seen twice since then, carefully, at neutral locations. That relationship is being rebuilt slowly, which is how it has to be. The house is still mine. The garden is still going. The tomatoes came in well this last season. The cararoo come through every few days. The sea does what it always does. I am 67 years old. I live alone, and I sleep well. And I know what day it is. There are things I learned through this that I want to say plainly, because I think they are worth saying. The first is about power of attorney. A general enduring power of attorney is one of the most powerful legal instruments one person can hold over another. It is necessary in the right circumstances if you are genuinely incapacitated and need someone to act on your behalf. Having the right documents in place matters enormously, but a general enduring POA covering property, finances, and personal care simultaneously, given to a single person without limitations, creates significant vulnerability. If you are setting up a POA, ask your own solicitor, not a family member's solicitor, to review it independently. Consider whether it needs to be general or whether it can be limited to specific circumstances. Consider a joint or co-attorney arrangement with an independent professional trustee, not just family members. The second thing is about the signs. When family members begin making comments about your memory, your confusion, your ability to manage, pay attention to the context. Is this coming from a place of genuine care? Or is it coming alongside other conversations about money, property? What will happen with things when you are gone? The two can coexist. Concern and self-interest are not mutually exclusive. But when someone is laying a paper trail of cognitive concern, it is worth understanding why. The third thing is this. The Public Trust in New Zealand offers free, independent advice about exactly these situations. The Citizens Advice Bureau can help you understand your rights. Age concern. New Zealand has services specifically around elder financial abuse, which is more common than most people realize and more often committed by family members than by strangers. If something feels wrong, if a document is put in front of you at a lunch table, if a family member is speaking to your GP without your knowledge, if a solicitor you have never met is described as working on your behalf, you are entitled to pause. You are entitled to take that document away and have it reviewed by someone who works only for you. The fourth thing I want to say is the simplest. Age is not incapacity. Being 67 or 72 or 81 and living alone and sometimes telling the same story twice does not mean you are no longer the person best equipped to make decisions about your own life and your own property. It means you are a person. It means you are living. Anyone who tells you differently is not acting in your interest. I pulled weeds that morning. I watched the sea. I knew what was coming up. The driveway before the car door opened. 40 years of looking at numbers and documents, and the small ways that people obscure their intentions had given me that much. I made tea. I sat across the table. I waited. The boxes went home empty. That is all a house is. In the end, a place you have lived and loved someone in and kept going, one season after another. It is worth protecting. You are worth protecting. If no one has told you that recently, I am telling you now.